Hello, ladies and gentlemen. Happy Friday. It's January 23rd, 2026, 2:48 p.m. Eastern Standard Time. So, as you can see, I completed my graduate program from Grand Canyon University. It's a Master of Science in Criminal Justice Legal Studies. And I have to tell you, I am shocked. The whole experience feels surreal. I'm like nonplussed, ineffable. I don't even know how to describe how I feel at the moment to know that I made it. Because this program, unlike my other masters in education, was very difficult. Now, I will say my other master's in school counseling was to me an extension of my baccalaureate degree in social work. So there's a lot of cross references. The biggest difference I would say is we learn more about theories in terms of education because it's a school counseling master's degree, and of course because it's a graduate degree, everything was like double the work. We had to do a presentation every day. It was very extensive and it was crazy. I'll be honest with you. I was like, wow, like I noticed a difference right away. I'm like, this is what people have been talking about with their master's degree. The volume of work. It's very different from your undergrad, even though undergrad degrees can be challenging. It just depends on the classes, the instructors, like lots of variables, right? And the discipline. But the master's degree is not the same as the bachelor's. That's why they call it a graduate degree. It is very challenging. Many people don't make it. Some do make it. Those that don't give up on themselves. But it is very challenging. It's definitely not easy to get. And once you earn it, it feels like a major milestone. Your bachelor's is too, but the master's is on a different level because it's an advanced degree, right? And it's one of the most popular degrees is the master's degree. So my second master's, as I mentioned before, criminal justice legal studies, it's a 4 credit per hour program and it's 10 classes. Very, very, very challenging because you have to become like a lawyer, like think like a lawyer. Very Socratic. You have to be a Socratic thinker, right? And you learn things, for example, about different sources of law, primary and secondary sources of authority. You learn about administrative, case/common, statutory, constitutional law, the ranking order of the federal constitution, statutory, and regulations, like different rankings of law in a descending order. You learn about historical dates of case law, such as 1803 Marbury versus Madison, involving judicial review and writ of mandamus. Branches of government, 7 articles of the Constitution, for example, full faith credit clause and exemptions. What else? The process of ratifying laws, reporting attorneys that violate the model rules of professional conduct through the ABA and the Attorney Grievance Committee. And there's other comparable committees as well. Variegated legal arguments, strategies when averting a case using primary and secondary sources of authority, and case synthesis, legal rules, procedures, penal codes, motions, writs, legal briefings, memorandum of law, the circuits, the 13 circuits regarding district and court of appeals. And I mentioned before, models rules of professional conduct, model code of judicial conduct, canons for Supreme Court and magistrate, so Supreme Court judges and magistrates. We all know that there's, 9 Supreme Court judges. The 8 are called associate justices, and there's 1 chief judge. Now, whenever a case, let's say somebody wants to file a Supreme Court case, there has to be, they call it the rule of four, a corpus of at least four, I'd say not corpus, excuse me, quorum of four judges that will accept the case in order for it to be heard by the Supreme Court. So a quorum of four or above. If it's anything less than that, then the case does not go through. It gets rejected, right? And the Supreme Court receives between 7,500 to 8,000 petitions a year, and it only accepts about 100 to 150. Can you believe that? Most of them, I can't say all of them, most of the cases that the Supreme Court orders a writ of certiorari on deal with constitutional violations pursuant to Article 6. In most cases, I can't say absolutistically, but in most cases, right? Anyway, so we also learn about the compulsory, peremptory, linguistic, canonical interpretations of constitutional law, federal statutes, case law, stare decisis, common law, etc. We learn about true bill of indictments, writs of certiorari, a Supreme Court, as I mentioned before, when it comes to appeals, interlocutory appeals, contract law pursuant to the UCC, which is the the Uniform Commercial Code, tort law, and the variances such as intentional, unintentional, strict liability, vicarious tort, which is also known as respondeat superior. I mean, the list goes on and on. Common law, promissory estoppel, detrimental, which is also known as detrimental reliance, unilateral versus bilateral contracts, procedural due process and substantive due process, jury versus bench trial proceedings, voir dire process during jury vetting, a propensity evidence rule, and motions in limine, when to file, and of course, in the absence of the jury panel, de jure versus de facto dynamics, Supreme Court rulings, case law, as I mentioned before, stare decisis, history of criminal justice, and pioneers such as Caesar Beccaria and other criminologists and phrenologists. Ambit canons of the 7 articles of our Constitution, descending ordinal rank of federal and state laws, criminogenics, as they relate to criminal behavior, criminal justice theories, dynamics of top-down versus bottom-up managerial models within criminal justice organizational structure, federal and state grant writing and proposals, cross-sectional versus longitudinal, quantitative, qualitative, temporal, spatial, inductive, deductive, random, cluster, systematic, etc. sampling when it comes to research designs and the various evaluative instruments used for the same. Legal writing and research as a legal practitioner, crime mapping, crime investigations and applications, accessing legal databases, various policing models, for example, direct policing versus community-based policing, crime data analysis and interpretations, providing consulting work as a government legal compliance officer, constructive service in litigation, interrogatories, and much more. Very, very challenging program. I see why attorneys charge what they charge. This is an alternative law degree because, there's 5, I believe there's 5 official law degrees, like, the JD, there's JM/MLS, which is basically just different vernaculars or terminology, but they're basically the same thing. They're law degrees for non-attorneys because, again, they teach us how to think like a lawyer without being one, because not everyone wants to be a lawyer, right? But, they can also use this knowledge to represent themselves pro se or pro per. So that's the benefit as well. But, there's an LLM, a Master of Laws, like there's all these different things, whatever. But it was a very rewarding program. I feel incredibly empowered having this legal knowledge. But I always tell people, if you're an academician and if you're like an epistemophile, as opposed to an epistemophobe, I would recommend at least having one law degree because it's an invaluable asset to your panoply of education.